Wakili Kibe Mungai and also Kipchumba Karuri. They should be here any moment from now. Wakili, good to have you.
Yes, good morning.
Good morning. Yeah. At least you can afford a smile.
Well, of course, we are live. God has given us life this morning. So we always have something to smile about.
Quite a disappointing ruling for you?
Quite disappointing, not just for me, but for the entire country.
All right.
And I say so because I am not looking at the BBI as an event. It's a process, or rather it was a process. And it was a process that was destined to benefiting Kenyans.
Right.
But all what we got from the court actually worsened the situation. Instead of them dealing with the issue that was before them, they actually went beyond what their call of duty. And that's why I'm saying actually Kenyans and those guys who call themselves the Wanjikos, the Moras that were referred by the judges. And I should think then I could also use this unfortunate terminology of the hustlers, should then begin to lament and to think, where do they fall within the armpits of the Constitution?
Hold it right there. When you say they went beyond their duties, just exactly what do you mean? What is this that you suppose they surpassed, in coming with the deliberations as to the ruling? The judges were called to determine whether the High Court was right in making it impossible for the Kenyans to amend the Constitution. They were not called to amend the Constitution themselves. But what we got from that judgment is actually an amendment to the Constitution, to the very Constitution that they were purporting to protect. Why do I say so? The matter in issue essentially was dealing with Article 257 that deals with the entire aspects of the popular initiative. And when the drafters of this Constitution, and when the Kenyans gave themselves this Constitution, they gave the procedures that they would wish to follow while effecting any amendment to the Constitution. And you suppose the judges are now coming in to limit this?
They actually went beyond the procedure. Article 257 has provided what a person who seeks to amend the Constitution through the popular initiative is supposed to do. As it is written in law, the person is supposed to have a bill, collect 1 million signatures, and take those 1 million signatures to the IBC for verification. That upon verification of these 1 million signatures by the IBC, then the IBC will roll out the process of taking the bill to the county assemblies. If the county assemblies, of course, agree with the promoter, then they return the results to the IBC. IBC submits this bill again to the National Assembly and the Senate. And then the process of the referendum ensues.
The judges highlight the gray areas in these procedures, and we all agree that it's fine. We went through all these procedures, but probably hurriedly, so to speak, or there was a lot of gray areas.
Yeah, it would have been.
And we probably would have expected the 4 million Kenyans who appended their signatures to this probably to be in the streets today, in protest to what it is that the judges concluded. But we haven't seen such just yet. Does it speak volumes?
No, it doesn't speak volume at all. For one reason, the 1 million, the 4 million Kenyans who supported the process, they have faith in the judicial system.
Okay.
We are yet to exhaust the available judicial mechanisms.
That is to say that you are proceeding to the Supreme Court?
I can already see the AG saying that
the AG, is proposing the same and has a couple
to go to the Court of Appeal.
Of things that he presents.
Supreme Court, yes. And because there is need to go to the Supreme Court so that we can ascertain whether Wanjiko has the capacity and the power bestowed upon him or upon her by the Constitution. Remember, the Constitution provides that power belongs to the people.
Yep.
and that the people shall exercise this power in accordance with the provision of the Constitution. So when you move to amend the Constitution and Article 257, popular initiative, you actually exercising that power in accordance with the Constitution. You remember I mentioned that the judges went beyond their call of duty.
Yes.
They went beyond the 260 chapters, articles of the Constitution, and it amended the Constitution themselves. How?
How?
If you look at what the judges directed, they said, one, the basic structure is applicable in Kenya. And I don't know whether Kenyans understand what this basic structure is all about. The basic structure is just, I would just call it in a simpler term, the tenets, the principles, and the theme behind the Constitution. There are those things that Kenyans said that we would want to protect the sanctity of these provisions. We would want to protect the fidelity of these provisions. Why? Because of the previous experiences that Kenyans had undergone through, where the parliament and the executive would arbitrate the Constitution left, right, and center. So we protect some particular clauses, and those clauses are actually protected under Article 257. So the basic structure means that you cannot just easily amend these provisions. We all agreed that there is the doctrine of the basic structure. And I know the person who introduced the whole idea of the basic structure.
Yeah, the basic structure doctrine is what we're talking about.
He will be among us this morning.
Yes.
Because it's not the first time that the basic structure is being debated in our courts.
Yeah.
You remember the case of Njiru that they kept on debating?
Debating, yeah.
You'll be lucky to host one of those persons who actually entrenched that doctrine in our laws.
He'll probably expound why we are so confused about this.
Yes, my learned senior,
we seek advisory.
Kibe Mungai.
Right.
Kibe Mungai is the one who imported this doctrine to our jurisprudence.
Yes.
From India. But the judge said, if you want to amend the Constitution, Wanjiku must conduct public participation. Wanjiku must conduct civic education. Wanjiku must conduct or constitute what we're calling primary constituent assemblies.
All right.
There is nothing wrong with these proposals, but there is everything wrong with the pragmatism of the proposals.
All right. Hold it right there, Wakili. I know there's so much for us to learn. And in this point where it is a matter of interest to all us, we are left with no choice but to have proper understanding of what really could have informed that decision. But we'll be giving you updates on that in the event that there's more that hits the desk. But we go back to the gentlemen, probably just to loop them in regards to this particular scenario where we now get the vaccines into the country. Still, lots of issues arise in regards to safety and that aspect where we now have civil servants being treated to that. I don't know whether it's a good thing, and I'm sure there's probably someone who's going to arise and say that they're going to hit into the courts to challenge the same. Does it have to get to that level is one thing that we ask our question. Do teachers really have to be pushed to a point where they have to take the job? If they do not, then they miss out on their salaries. What does this speak? And I am glad that Wakili Kibe Mungai is with us this morning as well. Wakili, good morning.
Morning to you.
I didn't have a chance to say good morning because then we were listening to that, but we're glad that you're here.
Yes.
And I'm told that you'll be the person who will expound some more on this one thing that cracks our heads as to this doctrine, the structure doctrine, and all that played out hugely at that particular ruling that we saw on matters BBI. But even before we delve into that, we have the vaccines landing into the country, and it's something that we celebrate because we understand how it's been hard for African countries to access the vaccines. But on this matter where civil servants, teachers are supposed to be pushed to make sure that they take the job, in the event that they do not, they are being threatened that they're going to miss out on their salaries and so much more. Does it really have to take that direction?
I do not think so, because vaccine at the end of the day are matters of personal health. And it should be a matter of convincing everybody without punitive action that it is in their best interest to take the vaccines. Whereas I've taken the first jab, but I cannot dismiss the fact that very many people had a lot of concerns about it. Those concerns are valid, even in developed country. I don't think there is a country apart from Israel and probably United Kingdom where you have more than 70% who have been vaccinated. The United States have done a lot, but even they are at about 60 to 70%. And it should be a good thing, but to use coercion that people be vaccinated and to say somebody cannot do this or the other, I don't think that is right. But teachers, policemen, and other people who are frontline workers, in my view, should be convinced that it is good, but the other stronger measures, I don't even think they have good legal basis for them. I don't think it's the right move.
This is likely to be challenged, Wakili. Ndegwa, yeah.
Well, you know, I think they should use much more of persuasive approach than coercive one, and I agree with my senior counsel, Kibe, that it should be much more of persuasive approach than coercing them to do it. But there is good reason why the government is a bit apprehensive if the teachers don't take this vaccine. You know, they are interacting with our children, with our pupils, with our students, and the government is apprehensive because one teacher might be a super spreader to about 50 pupils in one class. That will mean that at the end of the day, 50 families will be infected. So there is good reason for them to be apprehensive, but then again, teachers should not even be, or civil servants should not even wait for coercion. It should be something voluntary and something that someone feels that, yes, I'm obliged to do this because you also need to protect your own life. So what the government needs to do to make sure that uptick is much more entertained is to demystify these fears that came with the vaccine. You know, people are still in the dark as to whether they could have some side effects and all that. But for me, I've taken the jab. I took the first jab, I took the second jab, and I'm still alive. I haven't, my blood has not yet clotted, so I could be.
They would tell you don't celebrate just yet.
Although the only other issue that needs to be mentioned is that it is not scientific. If you can still spread the virus even after you've been vaccinated.
Yes.
And therefore, there is no and even in some other countries, they are saying you may need boosters, that even the first and second may not help a lot. But if it helps personally, the person who gets infected, to ensure that you don't get very seriously ill, is actually meant for personal protections, to protect each other, social distancing, wearing a mask, avoiding crowds. Those are the issues that there should be a lot of emphasis on. It is also my view, while we are at it, to mention that though the government is trying the best it can to acquire the extra vaccines, that probably a lot more can still be done. I'm not sure that it's 100%, because if, for example, we hear these from the Western countries, you do not have a lot of vaccines. These vaccines from Russia, Sputnik, that even the Germans ordered, I am not sure what is wrong with Sputnik and why, for example, we cannot be able to have many sources of these. Because like the vaccines from the US, Moderna, and and AstraZeneca, those Western companies, you still have situations whereby even after almost vaccinating everybody entitled to be vaccinated, they will now go for the third one when everybody else in the world has not been vaccinated. So these are big issue, but I tie it up also with the issue that countries like Kenya and others, how much price at the economic level can we continue to be paying because of this? I was joking with my university classmates the other day that personally I've suffered up to 70% income reduction. There are people who have suffered 100%, and these are people even whose original means was not there. So that because of these big issues, Sometimes I'm actually just tempted to ask that, to ask the government, why can't life just be as normal as long as people observe the rules? And by normalcy, I mean, let us just at least work. If I can work 24 hours.
Measures that are not
precisely,
really
let's work 24 hours.
Okay.
Because now you are seeing a situation in which probably greater suffering. And you see, one of the irony about all this is that the actual working population that is not even, for the time being, you cannot freely get the jobs, is that is least affected is the main working population. The populations between 20 years and around 45 years, isn't it? So why can't that group that we need be told you can work 24 hours if you can?
Okay.
Because there is a,
There's been so much of a huge
have a
difference, you
problem
suppose?
with whether what we are doing is smart. Because while we are waiting, we are not getting vaccinated. So we are waiting like sitting ducks, which is not something I associate with intelligent people.
Okay.
So
Well, interesting to watch, as I mean, for the longest of time, you know, people have called upon the president. And I mean, the other day, this was challenged in court.
But you can see council is vouching for the Russian vaccine.
not really them, any vaccine,
any vaccine.
anything, anybody who can be jabbed.
I'm more specific about the Russian one.
Yes.
The Putin one. And the question then is, why can't Kenya then be able to probably order those vaccines? But I think it also has some bit of where the country really inclines in terms of economic ideologies and the political ideologies. To the sense that Kenya being what it is and inclining to the west, they may not want to be seen as if they're inclining towards the south. And you remember the Cold War effects. So probably those ideologies and mentalities of the Cold War might also be playing out in the vaccine realm, and we are yet to see. But I agree with Kibe that at least we need to open up. But even as we open up, Kenyans are not taking care of themselves.
That's a reality.
They are breaching the protocol every day, now and then. And not just Kenyans, even those people who are highly reputed. They are breaching the protocols. We saw them yesterday when they were in church. They did not have the guts or the chills to at least understand that we are in an epidemic situation, and therefore they need to at least observe the COVID protocols. And they were shaking hands left, right, and center. I want to mention names.
More reason why probably we should just get over and done with the measures.
In fact, the bigger issue, even as you deal with that issue, the bigger issue for me, if vaccine, if COVID-19 is such a big thing, okay? It is a big thing because very many people have died.
Yes.
But if it is big enough in our consciousness, I think the quicker decision that, in my view, I would make if I had the power to make, is with regard to whether, because now in the next 1 or so months, the campaigns will kick in earnest, and you know the kind of campaigns that we have. Should we then hold this election in August next year with COVID-19, or, which is a lesser cost, should we open up the economy so that we can work? Because for me, if you are going to go for this campaign, no, let me finish this point. Yes. The fundamental point.
Yes.
If you are going to say, I see fewer people who simply by working at night for 24 hours, you would spread more disease compared to saying, we have full-blown campaigns, and that is okay. Okay? So that's why I'm saying there are decisions to be made.
And we've had whispers of this.
Actually, the COVID-19 issue has actually even been dealt with in a judicial perspective.
And I'm asking, I mean, the president proceeded to review the curfew hours at a point where that ruling was successfully made.
Yes.
That, you know what, the petitioners were lucky enough and were good enough to successfully argue this in court.
The Court of Appeal on Friday made serious observations that the BBI was actually being initiated in violation of the COVID and in ignorance of the COVID situations. So on one hand, we are saying that we want to essentially look at the COVID situations, when we want to probably amend the constitution. On the other hand, we are saying that we want to relax the COVID situation because we want to do an election. I think we must be we must be candid on what exactly do we want, so that we can at least give some certainty to our people.
Right.
Yes.
Okay, well, interesting conversations right there. We leave it at that. We all know that there's been whispers of the fact that maybe we should have a review of the dates of the election, and hugely that will be triggered by the COVID-19 situation in the country, because then, you know, all this that the constitution envisions in the event that we wish to postpone the dates of election, we probably are not at such levels anyway. That aside, Wakili, you came in while we were just having a conversation as to, you know, the ruling on Friday, and the Attorney General, in his last-ditch effort to save BBI, as has been captured by the papers, he has raised 5 grounds of appeal he feels will overturn the decision, among them basic structure doctrine, presidential immunity, and president's rule in law changes. Before you expound more on this basic structure doctrine that everyone is now talking about, Wakili Ndegwa here is of the idea that judiciary, you know, overstepped its mandate, has gotten to levels of limiting ways in which the people are able to amend the constitution that they made themselves. It is obvious that the duty of the judiciary is not to tell people how many times they should proceed to amend their constitution. This statement by one Justice J. Kiage, that Kenyans cannot amend the constitution at the slightest urge, even when it is being used to strangle them to death. Unpack that for us. Is it a way of limiting strengths or levels to which Kenyans can decide to, you know, amend the constitution?
I listened to Wakili Ndegwa while at your reception, and I could not agree more with the idea that once you have a written constitution, by the way, are actually written in order that to remove doubts about anything, so that if you say you cannot appoint an MP to be a cabinet minister, that is, you cannot hold those two positions simultaneously, it is clear. That's why it is written. Now, if the constitution says that you can be able to amend the constitution this way, and you follow every step of the way. Now, if the court were to say that there was something else you ought to have done, then the issue that you introduce is this. So how could anybody have complied with that in advance? Because remember, all serious issues are written in the constitution and not left to the discretion. So those who are advising the BBI proponents, how could they have known these other steps if they are not written either in the constitution or in a law made by parliament? So that when it comes to lawmaking, the constitution is a kind of law of 2010 that the people endorsed in terms of these proposals were made, and finally we agreed on them, and they are clear. So if what was actually endorsed by the people cannot be implemented without the judiciary either saying yes or second guessing you, you have done everything you ought to have done, yet you are told you are wrong, then you get a situation in which, number one, does such a judgment actually support the people? Because if the people endorses a document that says if you do this way, you can amend the constitution. If you go against that as a court decision, is it a pro-people decision?
Yes.
Number two is if now it becomes now so difficult that without reference to the courts, you cannot amend the constitution, there is a serious, bigger problem that you would have committed. And that issue is this. Many lawyers are probably aware of something that they call whether a question is justiciable and the political doctrine question. You may have heard something like that. What that the political doctrine question talks about is this: there are certain matters that should be resolved in the political arena, and political decision must be based on. And there are certain others that renders themselves, that is, and largely legal issues, as it is a legal dispute, to resolution through the courts, and using legal mechanisms. Now, with regard to the sense of the 2010 Constitution, how can we improve it? How can we ensure that we do not have a system that locks up political choices so much that you can have a high voltage election that will go out of control. Now these big issues, you leave them into the realm of politics. And the realm of politics basically remains individuals. The key individuals can sit together and say, these and these we can be able to change so that we can ensure people will not fight. At the end of the day, remember, like it was in 2008, January, February, okay? If the country goes to the dogs, peace and order and civil order are threatened,
right,
nobody would go to the High Court or Court of Appeal. People will have to go to politics and say, why are these problems not being fixed? So that for me, it is a big issue when suddenly you appear to have locked out the normal dynamics of politics from being operating to say, you solve the problem. Remember, I keep telling people a simple example. If people are not getting things, and I'll come to that even with regard to BPI,
yes,
I don't think the legal profession, both the ones advising the politicians and those deciding these cases, have done this country any favor. There was a lack of statesmanship.
One of them is
all,
here.
all around, and one of them is here, I know
Yes.
that. But he was playing a minor role.
Right.
There were bigger guns
role, yes.
who are playing a bigger guns, and we can go into the details.
Make us understand
Let me just, as I finish that point.
Yeah.
Now, when you also now, and some politician like you say, for example, if people are fighting the Pokots and the lawyers are fighting, now you don't go to court. You ask Uhuru, Ruto, and Raila can do something about this.
Okay.
Because it is assumed that belongs to a different docket. If we are not sorting these issues of COVID, we ask the medical profession, is in any view getting these things right? So that we can sort the issues. If it is a roads problem, we talk to engineers. But now what has now happened, unfortunately, with regard to a very crucial issue, is that the scope of the political arena to decide legitimate political problems has been taken away. And this is what the phrase they use, the judicialization of politics.
To be fair to
Wakili
Ndegwa, let's
Yes.
look on that very point.
Yes.
I am getting confused, and I would
Yes.
want to believe any other Kenyan is confused as at now. At what point does the court come in? When there is a petition that has been presented to them, right?
Yeah, the court can be set into motion at any given time because it's the right of any person to approach it.
And that's
But
exactly
it's the
what happens. So
responsibility
why
of
would
the
we
court.
fault them?
It is the responsibility of the court to determine whether something is justiciable. Justiciable is whether that something can be litigated before that
All right.
court. And in the
Justiciability. Wisdom of the court, they saw it.
And the other thing is whether that thing addresses the political question, as counsel says, as Kibe says. So what happened in these circumstances is that the court just matter itself went full throttle and was not able to determine whether the matter that was before it was matters that can be addressed or determined or argued before the court, or it was safe to leave them for political arenas.
If they were left for political arenas, how? What would be the conversation?
Let us use a real example.
Yes.
The court, including the CJ, they have done themselves lame on the issues of women representations.
Okay.
They want that gender rule. Supreme Court announced itself, the Court of Appeal, and even the Chief Justice.
Right.
Now, BBI, for example, was proposing how to fix that problem. Now, that problem has not gone away. The president, as of now, can actually today say, to prove, in fact, if I was a devil's advocate, I would tell them, to prove these people don't think, just act what the CJ told you.
Okay.
Okay?
Dissolve
He's the one
parliament.
who went to parliament to stop the
Yes.
dissolve parliament.
Yes.
So that we can say, why didn't we go to the courts to resolve it?
I'm
at the end
curious
of
to
the
understand
day,
the roles of the court
precisely,
constitutionally.
Constitutionally,
Yes.
there is an interesting area, and I'm happy you're asking that question, where it is called that in constitutional adjudication, for example, and you saw even a decisions on BBI, and I was at a ceremony somewhere where some people are making fun of the High Court when it was deciding on some health issues.
Yeah.
And like they were saying, if there is a issues of the COVID-19 rules, who should make the decision? Should we defer to somebody? If our health experts and their best judgment, and you see our president, you have seen Boris Brown, is it called Boris what?
Johnson.
Boris Johnson. I've seen the president of the United States. They always, when they are speaking on these issues, say, this is the advice that we have received.
Yes.
And I'm communicating the decisions, we are going to do things this way. So you defer to somebody where you say special expertise is required, or the nature of the business requires so and so to solve that problem.
Yeah.
Now, in politics, for example, you can be able to declare yourself that that we need more women to implement the 2/3 gender rule. Okay? Now, if that's all you can decide as a court, how are we going to go about it? You leave it to the same politician.
If the politicians were genuine enough, you know, you're a senior to Ndegwa,
Yes,
and therefore he would just keep quiet the whole time.
Yes.
Allow him to speak. And he will talk.
I don't interrupt.
Wakili, to be honest,
Yes.
if we were to take that direction, and we probably are going back to where it is that we would have started. We have
Yes.
seen opponents of the Building Bridges initiative arguing that, you know, these are things that can be amended at the level of, you know, the National Assembly. If we were keen to allow the politicians take up the mantle, don't you think that if they were to listen to all these cries and all these talks of, you know, doing this at the level of the National Assembly as opposed to, you know, triggering a conversation of a referendum, we would not have been where we are today?
Would still not have escaped to be where we are, because
Oh, yeah?
Parliament would not have been able to initiate some of those amendments without still referring back to the people.
Okay.
Because the Constitution, like I said, it has protected some various aspects that you cannot just amend them without getting back. For example, where we were saying that ministers will then be coming from Parliament, you cannot amend such kind of a clause without referring back to the people. And my biggest problem with the judgment is that, and not because actually the BBI failed, but the question is for the future of this nation. Where do we leave Wanjiku in the future? Because what has happened, in my view, is that by putting into place these stringent measures of the procedures in which Wanjiku has to follow in amending this constitution, it has actually in a way entrenched parliamentary supremacy. Okay. For example, of one reason, you cannot amend. An amendment of a constitution requires various aspects. Among them is the ability to amend them because of the resources. So when for example, if you say that Wanjiku has to carry out public participation, you then have to take it like he has to carry public participation in the entire country. If you say that the ward is the lowest unit of administration, Kenya has 1,450 wards. Wanjiku has to conduct public participation in each and every ward.
Okay.
If you say, for example, in each ward, Wanjiku spends about 2 million, the minimum, then you multiply 1,450 times 2 million, you essentially realize that Wanjiku needs to raise 3 billion for him to be able to initiate public participation. So you ask yourself, which Wanjiku has all these means? Then Wanjiku has to do what is called civic education. We are assuming that Kenya has a population of about 20 million literate people who can read English and Kiswahili. So he has to print 20 million copies for English and Kiswahili for all these targeted Wanjiku. So if you say, for example, he uses about 500 shillings to print one copy, then that comes to 10 billion for purposes of initiating civic education.
Right.
So for Wanjiku to be able to roll out civic education, he needs 10 billion. Wanjiku has to go again and do what is called constituent assemblies. That means he has to do a BOMAS, a replica of a BOMAS. For example, maybe say in each and every county, 47 counties. The code did not tell us to what level and to what unit that you must disintegrate to, or you must generate to. So we are assuming that is going to...
The court can only deliberate based on the laws that we have in existence. Does it then speak of a scenario where we have lacuna in law?
These issues were not deliberated because the law has provided for them.
Okay.
These are judicial invention. It's a creation of the judiciary. These constituent assemblies, these popular initiative, these public participation, this civic education is not entrenched.
Are you accusing the courts of hijacking
what
the
they
state?
They followed the route in which we followed when we were enacting when we were replacing the 1963 constitution with the 2010 constitution. They failed to understand that we're not replacing a constitution, we are amending a constitution. So essentially, as I pass over to Kibe,
They have entrenched parliamentary supremacy because parliament is the only organ that can be able to mobilize these resources to initiate an amendment.
Yes.
What that then means, if parliament initiates an amendment that is very unpopular with the people then cannot undo
They have
it.
no choice. They have
Because they have no resources.
All right.
Remember, they have said that no government actor can initiate public participation. Not even a political party like ODM or Jubilee or UDA, which is financed with public funds, can initiate a popular initiative.
Right.
So where are we? So I'm saying it is not the BBI that has lost. It's actually the ordinary hustler, mwananchi, that has lost.
Are you of the same idea, Wakili? We come get your view on that very point. But first, we have to take this quick break. All right. Yes, as always, the conversation will be on. The gentlemen, legal minds here in studio, Ndegwa, Njiru and Kibe Mungai, as we decipher the ruling that played out on Friday as to the fate of the BBI. And very pertinent, points arise, even as we're having that conversation during break time. Wakili, this was an initiative that was being endorsed by key political figures in the country. And therefore, there was almost that feel that, they're going to bulldoze this into the throats of Kenyans. And therefore, a moment, while we might fault the courts, there are some people who are celebrating the courts for, exhibiting independence, as of course would be expected. What are the dangers of having such initiatives that are considered to be popular initiative, being fronted, being spearheaded by key political figures in the country?
I think the initiative, and I think I read an interesting article over the weekend by the governor for Laikipia,
yes,
on Abonderito, on the fact that across the world, both the Boma's constitution, the 2010 constitution is always an initiative of the people that is always spearheaded by them.
Yeah.
So that, as Ndegwa is saying, if there is any problem we ever want to fix in our constitution, unless we say it's perfect and I've got no problem with that, as Kibe Mungai, then you would find that you cannot move if you say the only people who are able to do mobilization, because politics is about mobilization. So that I can have something wrong, very wrong, but at the end of the day, if it is a political issue, I'll have to talk to an MP and explain to him and other political actors that we need to address this problem. Okay? So there is the nature of the business since Aristotle and since Plato. So that the significant issue probably we need to talk about Njoya.
Right.
The Njoya case actually never said per se that Wanjiku is omniscient or omnipotent. All that they said is that the actual power that can be exercised, which is the power of your vote, and which they say that you are going to sanction, okay, to approve in the referendum. If that power is retained, it is the reason why in 2005, Wanjiku said no.
Okay.
In 2010, Wanjiku said yes. Okay? So that's how that power ultimately can be exercised, the power by the people. But now, if you understand, if you tried to create a mythological, a legendary Wanjiku, who actually only exists in your court judgment, or in an academic sense, and not a real Wanjiku, that Wanjiku will do this or the other one, you actually weaken Wanjiku. Because like in this case, for me, the ultimate glory for Wanjiku was for Constitution of Kenya 2010 bill, finally Wanjiku to be asked. Wanjiku, do you agree with this?
Or not?
And each of the 20 million or 18 million Wanjikos would have had their say on that. So that from the perspective of the Njoya decision, the country is poorer. That a bill that that Wanjiku was supposed to settle, whether this is right or wrong, the courts have decided to replace Wanjiku.
But
because that is exactly
there's still time.
No.
There's still time. Let's acknowledge that, and we still would want to trigger this conversation some more. like you rightfully put it, it appears as though Wanjiku is on the losing end on this one. Maybe the document had great things for the people of Kenya.
Yeah.
But reality is that a majority have really not faulted the document itself. In fact, a majority
Precisely.
The BBI itself.
Yes,
And that's why
the
it is,
document
we are
but they
poorer
have
for it.
faulted the procedures. Don't you think then that it was only fair that the courts protect Wanjiku in this case by getting this document, yes, probably sail through in a later date?
There was nothing wrong with the court faulting the procedures that were initiated by the IBC. They correctly found that probably IBC was not diligent enough in following the procedures. But where are we getting these procedures from? And the same has not been legislated.
Okay.
You remember, we do not have a fully Frenched referendum bill
yeah.
or referendum act. Whatever was guiding the IBC is what is domiciled currently in the Election Act. But the court went outside the Election Act. They even went and faulted the constitution and the composition of the IBC and the entire aspect of
and that's how will that come to haunt them hugely? I mean,
and you know, we're in a serious crisis, and this crisis has been created by the court, and that's why counsel is saying that if one wanted to be mischievous enough, he will just pull Maraga's letter and do accordingly. And then we shall plug this country into serious crisis because we shall dissolve parliament when we do not have a fully constituted IBC. So who will conduct this election? So if President Kenyatta was mischievous enough and he wanted to be a president for some reasonable period, he would just pull that card. And then we will plug ourselves into serious problems.
Okay.
For example, the issue of the IBC. The Constitution is very clear on Article 250 that there must be a minimum of at least three commissioners.
Yeah.
But what happened? The judicial innovation. There was a repeal provision in the IBC section 5. The court went, revived that provision, breathed life into it, and read into it that provisions of the repeal section 5 of the IBC Act supersedes Article 250 of the Constitution.
Okay.
So, without them knowing that even the judge who was presiding over that judgment, Justice Musinga, is as a result of the IBC investment. And remember, that office is holding as a constitutional office. The president of the Court of Appeal is a constitutional office under Article 164(4). What then that means, we then be able to ask ourselves, what is the legitimacy and what is the legal effect of this judgment that was delivered by a judge whose coming into existence is also faulty because the midwife was not well trained? Kibe.
And that's interesting. We probably are in the dark as to this. And I mean, you've had Kenyans asking, does it then render all the by-elections that the IBC has conducted, unconstitutional?
And even the legitimacy of that judge.
It is actually the irony of it all. Like, you see the question that needs to be asked about procedures. You've asked something about procedures.
Yeah.
Now, the main issues, there is no law even that is even expressly required by the current constitution, fortunately or unfortunately, on how at the end of the day you mobilize people and you get them either to bring a bill or a referendum question.
Okay.
The question actually, it starts with a certain stage that you've done all these and presented us with a bill or something like that, then we are going to process it in a certain way. So that if the constitution itself has acknowledged that we have a certain job, but this other job, how it is done and how you get people to support you, it has left to the imagination. That means it has already been left to the political world. You don't interfere with that. The same way, like there is a duty, I would call it. If the Kenyan nation is going to endure for the next 50 years, then people like you and Ndegwa, who are in the age where you are supposed to reproduce future Kenyans, you must do the job of ensuring you have children, you have future Kenyans. But are you told with whom, how to go about it? It's left to your devices. But it is the most important national project that people must engage into. So that the idea now is this, that if the constitution is written and about the procedures, certain procedures are not prescribed, okay? So that you cannot really be able to say, you are now just saying, ideally, we should do this. Those things that are called ideally, write them first in the law.
Yes.
But in the meantime, there is a mechanism to do something. Because remember, throughout the world and in America, people talk about a constitution
Yes.
that has endured for a very long time. And you see, very few constitutional scholars actually ask themselves, I was thinking about this over the weekend, why has the American Constitution endured for so long?
Yeah.
For me, I would have one major issue.
After lots and lots of
Precisely,
amendments,
yes.
Yeah.
Yeah,
And reviews also.
one of the things that you find with the American Constitution is the fact that the American courts,
Do not.
and you have actually to salute the American courts, have a very clear distinction on the political doctrine questions.
Hold it right there. Hold it right
Why
there.
don't you
Wakili.
want me to explain?
Because, all right. Do you give him the blessing to proceed?
Let him finish.
All right,
let him finish
okay.
first,
Uh-huh.
because he's
Yeah.
raising a very fundamental
Point,
point.
okay.
Where our courts went wrong.
Wrong on this one. Yes.
Precisely. So that, for example,
Uh-huh.
with regard to the issues of impeachment, in the US, it's just an example so that people
Yes.
can get what we are talking
Yes.
about. Now, that issues of impeachment becomes a crucially important issue because they say impeachment is really trial, an exception of a trial, is a trial by political office holders
Yeah.
who are giving a political decision on your right to continue holding office. Is not a legal question. So that in America, for example, impeachment either of a judge or the official, you cannot take it to court. They are very clear about that. In Kenya, you have judges.
But look
where
at their
you have
political structures.
Wabora.
Look at how
We are coming to
well
that. Let me
composed,
finish
yes.
that point. So that because of that distinction and so many questions, they had a lot of problem with slavery, with various amendments. There are certain issues that they would say the states are going to decide this politically. Look at their constituencies, for example. All that the Americans would do is this, to say, how are we going to allocate, something that also BBI was trying to do, amongst the 50 states, how are we going to allocate the political power? Let us decide at their population. So that when you say you've given California 70 or 100 seats based on their population, then you leave it to the legislature of California to redraw those boundaries or to give us the constituencies. So that at the end of the day is a pure political process. Something like this was being done here in Kenya under BBI. You did not see any of the 7 learned wise judges with the imagination actually to be able to see what is our job, how is it done elsewhere, okay? You reduced it.
Okay.
Wakili,
let me ask this question.
Let me just
expound on what he says.
Yes. What council has said. What the judges did, they became much more philosophical and theoretical than being pragmatic to the circumstances facing Kenyans. For example, there's a question of representation. The bill was proposing on how to solve questions of representation. When what they did is they condemned and demonized the bill on the basis of who has brought this bill.
Okay.
Like what Kibe was saying. They looked at it like it has been brought by the president and the Honorable Raila Odinga. And they failed to look at the substance of the case. So
why would they have an issue with Right Honorable Raila Odinga and President Uhuru Kenyatta? Are you, once again, I ask this question. Is it evident that there is the judges or the
fact must be told,
judiciary versus state?
No, there is institutional rivalry and sibling rivalry that is existing currently in and one of the key indicators that these guys were actually responding to that rivalry, Justice Musinga dealt at length with the question of the constitution of the ombudsman.
Yes.
Right? The ombudsman, he said that we cannot allow a third eye to come and start investigating us, to have some kind of control over the judiciary. Yet, even when they have the Judicial Service Commission that is currently constituted of peers, they themselves are not able to do their own peer counseling. Why would Chief Justice, Deputy Chief Justice Philomena Mwilu continue to serve when her character is in question? You understand? So ordinarily, then people thought that, okay, it may not be a very popular idea, but at the end of the day, the Judicial Service Commission is not responsive to the wishes to the norms that Kenyans would wish to associate themselves with. Now, look at the question of the representation. they said that Kenyans cannot create constituencies, 70 constituencies. They misread Article 89 because Article 9 essentially gives IBC power to delimit and alienate boundaries.
Right.
70 constituencies were not being delineated or being delimited. They were being created. But they said Kenyans, Njiru has no capacity to increase the number of the constituencies from 290 to 360 or to whatever number he or she wants, even to reduce them. That power has actually been usurped. You might want to ask yourself, we are now in a digital era. Everything is being done digital. We are attending court through the platforms. Yes. So in the next 50 years or in the next 20 years, shall the live parliament still be necessary for us? There may come a time when you might want actually to say, even parliament will be virtual. Everything will be virtual. So we actually need to reduce the number of the members of parliament from 290 to probably about 90. For purposes of
constituency, there is actually a more important political question that we should address to. In the year, when was this? In 2010, one of the political decisions that was made was that all the then existing, were they 210? 210. The 210 were going to be preserved. Now, if now you want to be academic about constituencies beyond those ones, then you must also tell us these 210 constituencies that we decided are going to be preserved, how exactly were those constituencies created? These are state house constituencies. So that if 210 state house constituencies...
They were actually goodies.
If you go, why is Badhua there? It was to help Kamodo to be an MP. Why is Mungai there? Why is these constituencies of Uhuru, Gatundu South there? This was pure politics, 100%.
That is an acknowledgement, Wakili, that is an acknowledgement that we have a problem. Structures, structure-wise, politically, we are not stable enough.
No, that's not the position.
That is not the position, but also...
All right. I'm trying to make, which is this, you cannot be able to assume the high moral ground about certain constituencies when the bulk of our constituencies were actually created politically, and you are not honest about it. To say where were these 210 constituencies made?
We cannot continue doing wrong things.
You know what Kibe is raising a very substantial point. He's telling the judges that the judges were not carded enough with the truth.
That's true. Yes.
Because if they were carded enough with the truth, they should have interrogated how the 290 10 constituencies came into being. Even in the addition of the 80 constituencies when Legally Commission was constituted to do the 80 constituencies. Again, it was a political process. So what the court did is they have actually mutilated the 2010 constitution.
And acknowledging that.
And again, defranchised Kenyans. For example, you might want to take a constituency like Ruiru. Ruiru has 600,000 constituents, the residents. If you take the population quota that is designed by the constitution, you take the population for 47 million divided by 290. You realize that each constituency is supposed to host at least 165 constituents or members, right? So if you take 165, you subtract from 600,000 people from Ruiru, it means any other person over and above the 165 is not represented. But when you want to solve that problem in a political process, the court comes and says no. You cannot solve this problem.
All right, let's acknowledge this.
It was important, and I think anybody who is determined to appeal this thing must at least invite the might of Kibe. To interrogate how was the 210 constituency created? It was a political
the people
process.
who proceeded to court to petition this is because they probably would acknowledge the fact that this is a political process, but then they do not have the confidence.
Let me even tell you a more critical issue that is even quite dishonest. I believe I read these decisions, two crucial issues at the High Court. One, the legality of the Constitution of Kenya 2010, that this Constitution, that those amendments would contradict the Constitution, was never a direct issue at the time when all these petitions were filed in them. The issues of the sixth schedule about the 210 constituencies was also never a direct issue. And I don't think the High Court even shied away from determining it as an important issue. So that you actually had, when you read them, and I will be doing, they say the judgments are coming out today. I'll do it technically.
Right.
That even at the technical level, I do not think, because the law has always been, to deal with an issue on appeal, these issues must have been clearly sorted and firm decisions made by the High Court. On important issues, that was never the case. But the Court of Appeal, and this is a departure from what it keeps on saying, decides to take up that issue, carry it on its shoulders, and now start ultimately making what are clearly the political views for the first time on some of those issues. That one, even technically, there would actually be a lot of problems. And I really hope somebody gets some of these decisions to the Supreme Court.
Okay.
Then there is a question that Ndegwa has raised, which again I thought there was an element of irresponsibility in the nature of, whom do we call them? The advisors of BBI. In the sense that it was obviously that the judges do not want somebody to see exactly how they do their business and how they carry out themselves. Politically, and I had gone to the Senate to say, this bill, there is nothing that would prevent Parliament from getting away some of these issues. One of them was about the judges. Now, you don't fight with the courts, and they tell you and they write you memorandum, remove extra oversight on us. That extra oversight does not have to be bad. But it is, you must also figure out an important constituency does not want something.
Right.
Get it out. And you will process it another day. Now, what do these guys see? An unpopular things with the courts. The judges know with a mere judgment, and this is a conflict of interest.
Interesting.
That they will solve their own personal problems.
Yes.
Now, when you give judges a chance now to solve their, it is always assumed that in the case that has been presented, the judges did not have a personal stake in it. This is not true, as he says about the judgment of Justice Musinga. The judiciary, as much as Tanga wanted to kill the bill. And that's an important issue.
Okay,
they wanted
therefore,
to kill that bill.
Yes. It's in the hope of everybody that that understands the key issues that you're raising, that the proponents of the BBI then would proceed to the Supreme Court. The likes of Right Honorable Raila Odinga have said that they would probably wish to just stop this for a moment and proceed with life, maybe find other mechanisms of making sure that the BBI sails through. What is the worst that can happen in the event that this is not challenged at a higher court? Because we also understand that there are constraints of time. Yeah.
The worst that will happen, and by the way, we should not go to the Supreme Court just to make sure that the bill sails through for a referendum.
Okay.
We need to go to the Supreme Court to set the record straight.
Yeah.
We need to go back to the Supreme Court to at least confer back the usurped power or Jiko's power, and confer her or him with the power that belongs to him. For one reason, if we don't go to the Supreme Court and leave this judgment as it is, then it means that Wanjiku should just sit helplessly. We are back to the 1963 Constitution, where Wanjiku had no say. Wanjiku could not make a determination. Let me actually don't even use the word Wanjiku. The hustler himself. The hustler has no capacity to amend this Constitution. The power that belongs to the hustler has actually been usurped. The hustler has no even capacity or ability to say that I want to make a determination as to how I will be governed. He or she has not that capacity. And it better be known to the Tanga. It better be known to the proponents of the hustler movement. That his group, the wheelbarrow pusher, the mkokoteni owner, the mamamboga seller, has actually lost under the armpits of a stroke of a pen. For persons, not because the bill had any poisonous chalice in it, or because it not sort out the Wanjiku problem. It's because the bill was unpopular to one political function and unpopular to the judiciary. And then, as Kibe says, it is important that such kind of judgments are also looked at another angle of determining whether these judges were actually impartial.
Okay.
Because when you speak to the question of the oversight, and you say that the judiciary cannot actually be oversighted, you know, you actually betraying yourself, like what the courts did.
All right.
And there has been also been these issues with Parliament. Let us also not forget. These issues of oversight is actually an important one.
Yep.
And I come from, and we are all in the legal profession. Namely being, for a very long time, for example, when the issues of how do you spend your money? Why do you keep insisting on building new courts when other courts are not concluded?
Okay.
Why don't you have permanent employees in the financial divisions of the judiciary? You see, when all these questions are asked, and then you say we are independent, you know, you just end up behaving like they are politicians. Like you are also uncomfortable with oversight. You are getting it. So that on this now also you also get concern that don't you also give the impression that in the same way, like for example, because it's out there, people say as we want a full-scale presidency, post 2022. In the same way that they said it, you also said, I also don't want oversight. And you said, and you got people brought some cases, and you seized the moment. That this is, I have an opportunity to stop what I could not stop politically. So that the question of legitimacy from the point of view, because remember even independence, and that separation of powers also means, the separation of powers means the judiciary decide cases in a manner that it is disinterested. It doesn't concern you. That's part of fair judgment. Did you meet that? When you in saying this bill is unconstitutional, it is also based on your own personal grievances. Because it is assumed, you see a judge, and they say that, I oppose the death penalty. But if I was to be a judge, and I have to make a decision whether somebody should hang or not, because the laws of Kenya says that person should hang, I must then make a decision that you will hang. No, I cannot make any other decision. If the evidence says that he should not be, I cannot use my personal views. But in this particular situation, Ndegwa is just saying, on the question of, we had our own grievances.
Fair enough,
You are litigating your own, you are a judge in your own case.
All right. Well, when we left the petitioners, anyway, I'll read two comments from either side, from two sides. Evangelist Kamundo says, I disagree with Ndegwa Njiru and Kibe Mungai in totality. Probably has his own reservations. Time would not allow us to go through that. Just found him on the other hand. We have to proceed to the next segment. Just found him on the other hand says, the Wakilis are raising very good points. Appealing to the Supreme Court will help our country develop jurisprudence. So we wait to see whether that will be the next thing. I also had a couple of questions here set for you.
Actually, jurisprudence is not even the key issue, because nobody can consume the jurisprudence other than the courts. But the question would be, where have we left Wanjiku? Have we uplifted,
what precedent
have we lifted? Have we actually crowned and acclimatized the parliamentary supremacy? Those are the issues for considerations.
Thank you so much, gentlemen. Wakili Kibe Mungai and Wakili Ndegwa Njiru. It was good having you. We're expecting to get Chumba Karori, probably would have countered this argument, but unfortunately he did not make it here. We hope to have this conversation some more. I still have millions of questions that I would have loved to ask, but all the same, let's leave it at that, as we hope to get another time to expound some more and understand some more on this. On to a different conversation on matters health after this break. Thank you so much.